make sense? So I'll take that out. Anything else in Article 1? What is the difference between the wind energy conversion system and a wind energy facility? Page 7. Page 7. No number. It's under definitions. Yeah. So just clarification, basically the same.
It talks about measurement tower in the WEF.
That includes a wind measurement tower.
Right.
So John, what I'm assuming is that under the WECS, the wind energy conversion system is basically
A windmill.
the turbine. And the wind energy facility is all the components of all the pieces. Yeah. That's clear.
The permits are in this section? Section 1?
Article 1, you mean?
Yeah.
As far as the definition goes, or?
Yeah, well, it says permits, and back here on page 10(3), it says any windmill tower existing on the effective date of this local law shall be removed no later than 12 months after said effective date unless a wind permit has been obtained. And, my question is, what happens to the windmill towers that the board has already approved?
My assumption when I read that was that a permit had already been obtained.
Well, we didn't have a special permit, but we did approve it, and our codes officer, I know the one on Bailey's, the code officer been out there, and that is 197 foot tall. Back in here, you're gonna limit the wind measurement tower to 150, so it couldn't obtain a permit.
That'd be a small windmill then?
No, we're talking about measurement.
There's also, once it's been up and approved, you do have the right to outlaw them, but you've got to amortize them, over a reasonable period. And it seems as though maybe a year might be too short a period. Yes, if that tower is higher than, what would be permitted under the law, is a year or reasonable period to amortize them. And I don't know what the useful life of a measuring tower is, or...
And some of them, I think, want to set up permanently.
Well, if it's permanent, what would the useful life of the equipment and all be?
I mean, technically, a turbine's only good for like 20 to 30 years.
20 years, they make 20, 25 years.
Yeah, for 20 to 30 years.
But I wouldn't think the measuring towers would have that kind of a useful life.
I don't either. I mean, if he said 5 to 10 years, pushing 10.
And there's a windmill tower, measuring tower on the school. Is that exempt from this law?
Not with any exemptions.
It's certainly wouldn't be able to get a permit under the regulations that they're proposing.
Did you guys see that they have wood measurement towers on trailers now?
Yeah, and Winter around and trailer too.
I didn't know that, but
Yeah.
I drove by, the drive 12D, or, what's it, Eon over there? And I saw a small trailer with a wind, measurement device on it.
Yeah, they have trailers and solar panels on the house.
So I guess the question that then begs is, if it's a roll-around trailer, do we have to classify that as law? They have a wood measurement tower on a trailer?
I'd say that's equipment, I didn't think we'd get.
Yeah.
Yeah, because it's not construction, you know, it's not. You put it up.
Back to 106A3 then, you on this? There are questions as far as any of the existing ones within the town.
And the height's governing the permit. If you get a permit, there's no stipulation on time. To get the permit, will fall under the height restriction. Follow me?
So leave it as stands?
Leave it as it stands. I wonder, should there be any preparation for a waiver from the planning board?
For the law guys in here? that-
Waiver from the planning board on permit issuance?
You know, that, as you go through the whole law, that's one of those things that's lacking as far as
Waiver?
a waiver or variance. You know, a typical land use regulation or zoning law would have a variance called a waiver provision. Under certain, circumstances. That, and the appeal right, or, appeal to the courts, those are the things that I saw that were missing.
It should be added in if we leave it alone and we leave it alone.
Well, and ideally, there should be criteria for a waiver or a variance. Just like a zoning board would have, criteria. It's all would have to be given as to when a variance could be given or not.
Would that be a recommendation from this board to the town board, along with this draft of the law, that type of provision be established? Would that make sense? Or consideration for such establishment? Did you get this on right? Everybody in agreement with that? Anything else in Article 1?
1.07, Item 2 would be, kind of goes back to the same thing. Page 9. Item 2.
Section 107B, number 2, at the bottom of page 9.
Because if they want to replace the existing structure exactly the same, why would they have to comply with the new law? If they were going to put up new style, new type, then I could see them doing it, but if it's, you're replacing the same windmill with the same structure, why would
The only thing I'm thinking right here is that regarding all, and tell me if I'm wrong, is the existing windmills in the town at this point in time would be compliant or would not be compliant under this law?
It wouldn't be compliant with setbacks.
Setback.
So the issue is, I think the issue that you will run into is the towers stay the same, they want to leave everything there, but replace the turbine,
Right.
you know, as they wear out. Assuming, you know, they still go, and so can they replace a turbine when they have all the other infrastructure there? This would seem to say no.
Right, they could be able to do it. Because of either setbacks or height restrictions.
Right. I mean, they would, I would think that any of the existing windmills would run afoul of, you know, one or many of those, you know, restrictions. So that, and it might simply be a question of putting in an exception with regard to, you know, for instance, replacement of turbines or replacement of, you know, existing infrastructure. I mean, I'm thinking of, you know, the transformer stations or whatever, you know, upgrading those. But certainly there would have to be some replacement or modification of existing facilities. Or you're essentially saying that those facilities will, you know, will, yes, the turbine or the wiring runs its useful life, that's it. And you could put limitations, you know, the towers could be changed, but the turbines could be changed. So that way you're not increasing the, you know, the height, you're not.
Structure is not changing anything.
Right.
Bill, what if you just replace the turbine, but you go with a larger diameter rotor, which in effect change like ice throw, blade throw, which would have an effect on the setback.
Yeah, but with the existing, if the towers are kept at the existing height, how much can you change those rotors?
I don't know, I'm just saying, but if they did put a larger,
Yeah, I mean, I would think that you would have, I mean, you could certainly put that as an, you know, the exemption would be, you could change a rotor, change blades, provided that they not exceed the existing, you know,
original dimensions.
original height of a rotor.
You maintain the same size
Right.
structure, right, your time.
I'm fine with that.
Say specs because, you know, it may well be that you would have a 2 megawatt turbine that's smaller than what was there before, and why it would,
Probably be more of an output.
you know, so you wouldn't want to restrict it to a, you know, the old specs.
Yeah, but grading capacity, blade size, rotor size.
The things that you see, yeah,
Structural part.
I would think, I mean, the hope would be the turbines would improve as the age, or, you know, as years go by.
Of course, they had all 1.5 or 1.6 megawatt output, and they changed to 2.7 and 3 megawatt output. And of course, nitrogen gets involved in it because they've been changing the load on the grid, which doesn't have a thing to do with the structure.
So where do we land on that?
As long as they maintain the same size and the height on the rotor.
Original structural measurements?
Structural measurements. there is that.
Okay. Anything else with Article 1? Nothing? Yep. We'll be getting into, unless you're looking at number 3 on top, I'll get into Article 2. Article 2, wind measurement towers. Any issues with anything in Article 2?
Section 2.03.
Page 10.
Indicate,
And page 10?
yes, it indicates that the applicant information and need name, address, and so on. Isn't that a private contract between two people, the developer and the landowner? And that's a private contract, therefore, you know, have they give up all that information?
That just says the information for the applicant, for the company coming in, applying for the permit. Right, right. I'm okay with that part.
Yeah, that is for, specifically for the, you know, the contractor or the developer.
No, number 2 is different.
Right, I agree with that too. We're looking at the next page on number 11, under number 2, property owner information. As it reads right now, property owner information, name, address, phone number of property owner upon whose property windmill tower, or whether wind measurement tower is supposed to be located unless the applicant is the property owner of the application. So include a written copy of the written agreement between the applicant and each such property owner granting the applicant the right to submit the information.
That was my, or that's what I was referring to right there.
No, the agreement, if it's just the agreement from the property owner saying to the applicant, you can put that application in. That's just, you know, giving that permission. It's not giving the rest of it. It's not the agreement for the wind tower.
That's not what it says.
The application will include a copy of the written agreement. The written agreement granting the applicant the right to submit the application and enter upon the site. That doesn't have to be his business agreement.
Well, that's the way I interpret that.
Well, and if that's what was intended, I fully agree with it.
Well, that's what I'm saying, that's where I was, you know, two individuals. If you and I had a contract.
It, you know, there's a big difference between saying, okay, we have the measuring tower for this tax parcel.
Well, okay, how about this? Property owner information, the name and address of the property owner upon whose property a wind measurement tower is proposed to be located. The written agreement, the written agreement should also identify the site by tax parcel. Oh, and to be identified also by the tax parcel.
Well, if you want to include granting the applicant the right to submit a written agreement stating they have the right to submit, that's fine.
I mean,
But the way it's, I would interpret that, it means you have to show them the agreement.
Right.
Right.
That wording needs to be clarified.
Yeah, okay.
typically what, you know, you find will be, they'll have their agreement, and they'll also have a memorandum agreement, which will simply set forth the basics, which are really the only thing that anyone else needs to know. meaning,
If there is a contract between the two.
right, and that the applicant has the right to apply for the permits.
So you're comfortable with that, the way it's working?
Well, no, I think it, because we've had a couple different interpretations, that indicates it needs to be removed.
I'm not comfortable with it.
I think the biggest problem I had with the start of that article is in 2.02 B, notifying by certified mail any property owner within a mile and a half or mile. The town law, the general municipal law, we have our, notification procedures. I can certainly see maybe joining property owners, but much more than that, I don't think is, I think it becomes an unduly burdensome issue. They might as well just get the town's mailing list and mail it to every property owner, and by certified mail is unnecessary, except that it pushes the cost down.
So if we include the town law notification procedures, and is there a time frame in those where you say it has to be 2 or 3 months prior to an application? Or is it just how it has to be done, who it is communicated to?
Well, they might be checking with a lot of property owners. I think as long as I guess I don't see the need for that, other than the fact that they register with the town clerk, and she puts it on the website, so that it's public knowledge. If somebody knows somebody's going around town, fine.
Because this is just initial stage.
Yeah, this is just
It's not
investigatory.
giving a permit out. We're not having a hearing for a permit, we're having just,
Just
notified.
access right to the town site.
I mean, if this was prior to contacting any property owner, I mean, all of a sudden they have to mail to half the town by certified mail because they're gonna go talk to somebody?
Yeah.
No. But if they're going to do business in the town as a wind company, fine, they have to check in with the clerk, so if it's no different than a DBA filing with the county clerk. If somebody really wants to know, they can go to the clerk and find out who's asking questions.
So that last line should be deleted altogether.
I mean, there are a couple of the provisions in here that I think are, unduly burdensome, and, yeah, I think, I don't see the benefit, other than causing a burden for the wind company. I don't see where it's beneficial to anyone else. Typically, if you sent out that many certified mailings, I bet you'd get half of them unclaimed and refused.
So there's established regulatory,
It depends what you're, giving notification of. But I mean, most, some people say, well, nobody looks at the town newspaper or looks at the town bulletin boards. But those are, for most of the legal requirements, be it for referendums or one thing and another, those are the type of public notices you give. But it is one thing, once an application goes in, a notification, say, I would think adjacent property owner, but 7,500 feet seems a little extreme.
So really, anything after clerk and town office should be done.
In that paragraph, I think so.
okay.
just because it's such a preliminary stage.
Back to 2.03, number 3. The distance. Map to scale showing the location of each proposed windmill tower on the site.
What
Property
measurement?
measurement tower. Under residence structure with 75 feet of proposed wind measurement tower.
If somebody just wants to put up a measurement tower, a survey of 1.5 mile radius, will probably cost somebody $100,000.
Or the towers.
So again, that comes back to the setback limit based on height. What's that say?
Depending on what, limits you're going to put in with regard to wind measurement towers, yeah, I mean, something, well, but a map to scale, and when you're dealing with structures, chicken coop and larger, for just putting up a wind measuring tower, that's a heck of a burden. I mean, I don't see, when you're going to require many of these things if someone was going ahead with a project. It may be reasonable, but when you're just putting up a wind measuring tower, and you, as I say, a map to scale, there's some requirements that, okay, if that's a survey map, I mean, you're talking a phenomenal number of dollars if you've got to show, every structure.
What about the same thing in adjacent properties?
Yeah, I was just gonna say, adjacent property.
Say other than the listing of GPS coordinates.
An application where the GPS coordinates should be included.
I beg your pardon?
Or reasonable radius.
GPS coordinates.
If that's necessary, over 1,000 feet,
If you saw the, adjacent property lines.
As long as you follow the setbacks established. You should be fine. Let's revisit that when we review the setback. Okay, I want to clarify, I want to get back to 202B. Where do we land on that? It would just be prior to contacting any property that's being accessed at a potential site, the applicant shall just notify the
You're taking out that second sentence. So the clerk puts,
Okay.
has to post more.
Gotcha, okay.
And she has the identification and knows who's asking questions.
Gotcha, okay. I'm okay with that. We're okay with what you initially said, 201, okay with that? And then 2, property owner information. In that, it would just be
Well, if you took out, if you said, unless the applicant's the property owner, the application shall include a copy of a written agreement granting, take out the next clause, between the applicant and the property owner. Just a copy of the written agreement granting the applicant the right to submit the application to her on the site. The agreement shall identify the site of the deck. So that clarifies that it is just, he's got to give basic information and he's got to show that he has authorization to be.
Okay. Everybody fine with that?
Yeah.
Page 12D, 7,500 feet.
D is a David?
D is David. I like the first part, Armstrong, I was 7,500.
About 15.
Excuse me, I have a question over here. Can people hear what's going on here?
No.
Absolutely not.
I think that if there's an election, it should be by elocution.
This is just a workshop with the board, sir.
Well, these people are all here to find out, follow what you're doing, and you're mumbling.
Again, it's a workshop with the board. We're not trying to mumble, we're trying to get through a document, that's all.
Well, we might as well not be here.
That's the idea.
That's what they like.
Shouldn't all distances be based on whatever the setbacks are?
I agree.
So if it's 1, 1.5, 2, 2.5, 3, whatever we agree on as a setback, should define that distance versus a set amount.
Well, or should you just, have public notice, of the hearing? The certified mail, I can see mailing a notice to adjacent property owners. But, the certified mailing doesn't do anything except add a cost. And, here again, the easiest way for them to do it would be just to get a mailing list of the town and just say the heck with it. The fact that it says the Mid-York Weekly, it would be whatever the town official paper is where it has to be published. They certainly can publish it other places as well. It has to be published in the town's paper.
Yeah, on our town's website also.
But it certainly, this could state that it should be on the town's website. I mean, legally it has to be published, a public notice for a public hearing would have to be in the official paper of the town.
That has nothing to do with neighbors, distance, kind of rights, so the community has to be notified. That's what that should state.
Well, if they want to have a reasonable regulations stating that, okay, we want to give specific notice to someone, such as adjoining property owners, or even if it's within all the people in the setback, sure. I mean, that's not an unreasonable request. I don't think it's necessary to do it by certified mail.
That's for the protection of the wind company. So if it gets to court, somebody can't say.
Doesn't matter, all they have to do is give an affidavit of mailing. That's all we have to do when we have to mail anything else for the town to someone, is they have to provide an affidavit of mailing that they mailed it to these certain people.
So to be totally fair to everybody, you shouldn't make a special notification to people that are neighboring or within a certain distance. You should let the whole town, Madison, know that there's this application and there's a dinner coming, and there's gonna be a public hearing.
And
So
that's
even
what the
if-
public hearing notice is
So
to
that-
publish.
as long as you clearly do that, then it gives everybody within the township the opportunity to participate.
Right.
Right.
Versus selecting a specific site category of people to come. So that's how it needs to be worded. So the website and the Mid-York Weekly.
Well, the official town newspaper, which actually, I think is Gazette Daily Dispatch. And some people like to see the Mid-York Weekly, and that's, fine, you publish it in both, but you should publish it in your official paper.
That actually came in later. You guys don't like that.
So give me something there, Bill, that makes sense in that sentence.
You've got, okay, the public hearing is for the first sentence. It's actually, the board is the one who should be publishing the notice, albeit at the applicant's expense. I think you should start that second